for your estate planning? In this video, we'll explore the key differences between wills and trusts to help you make an informed decision. First, let's talk about wills. A will is a legal document that outlines how you want your assets distributed after your death. It can include instructions for distributing personal property, naming guardians for minor children, and specifying funeral arrangements. One of the main advantages of a will is its simplicity and ease of creation. However, it's important to note that wills must go through the probate process, which can be time-consuming and public. Next, we have trusts. A trust is a fiduciary arrangement that allows a third party or trustee to hold assets on behalf of beneficiaries. There are two main types of trusts, revocable and irrevocable. A revocable trust can be altered or dissolved by the grantor during their lifetime, offering flexibility and control. An irrevocable trust, on the other hand, cannot be easily altered once established, providing greater asset protection and tax benefits. Trusts generally bypass the probate process, offering privacy and potentially faster distribution of assets. When comparing wills and trusts, there are several factors to consider. Cost is one aspect. While wills are generally less expensive to create, trusts can save money in the long run by avoiding probate fees. Flexibility and control also vary, with wills being easier to amend, but trusts offering more control over asset distribution during your lifetime and after. Privacy is another significant difference. Wills become public record through probate, whereas trusts remain private. Additionally, the management and distribution of assets can be more streamlined with trusts, especially for complex estates. So, how do you choose the right option? Here are some questions to help you decide. What are your estate planning goals? If your primary goal is to ensure your assets are distributed quickly and privately, a trust may be the right choice. How do you feel about the probate process? Trusts can help your beneficiaries avoid the time-consuming and often costly probate process. Do you have minor children or dependents with special needs? Trusts can offer more control over how and when your assets are distributed, ensuring your children or dependents are cared for according to your wishes. What is the size and complexity of your estate? Larger estates might benefit more from the flexibility and control that a trust provides. Are you concerned about privacy? Trusts do not become public record like wills during the probate process. In conclusion, both wills and trusts have their unique advantages and can be tailored to meet your specific needs. It's always wise to seek professional legal advice to make an informed decision.
Do you actually need a power of attorney? Or is it just something lawyers try to sell you? Here's the truth. If you become incapacitated tomorrow, who pays your bills? Who makes your medical decisions? Without a power of attorney, your family has to go to court. That process can take months and cost thousands. A power of attorney lets someone you trust step in immediately. No court, no delays. So ask yourself, do you have assets, a family, a business? Are you over 18 years old? Then yeah, you probably need one. Drop a comment if you've set yours up or tell me what's holding you back.
In this video, we will discuss how to set up a land trust, its benefits, and how it can protect your assets. What is a land trust? A land trust is a legal entity that allows you to manage and control real estate assets while keeping your ownership private. This can be particularly useful for safeguarding your assets from creditors, lawsuits, and other potential risks. With a land trust, you create a private agreement where a trustee holds the title to a property for the benefit of one or more beneficiaries. The main advantage of a land trust is that it allows the beneficiaries to retain control over the property while keeping their identities confidential. Key features of a land trust include privacy, control, and flexibility. The names of the beneficiaries are not disclosed in public records. Beneficiaries maintain control over the property, and they can transfer their interest in the trust without public record changes. What are the benefits of land trusts? People often choose a land trust is the privacy it offers. Since the trustee holds the title, the names of the beneficiaries are not listed in public records, making it difficult for potential litigants to identify the true owners. Additionally, by placing property in a land trust, it becomes more challenging for creditors to seize your assets. Creditors may find it difficult to discover the existence of the trust or determine the property's value, deterring legal actions and settlement negotiations. Land trusts also simplify the process of transferring property ownership. Beneficiaries can transfer their interest in the trust without triggering a public record, useful for estate planning and avoiding probate. How does a land trust work? To establish a land trust, you need to create a trust agreement that outlines the terms and conditions. This document identifies the trustee, beneficiaries, and the powers and responsibilities of each party. An experienced attorney should draft the trust agreement to ensure compliance with state laws. The trustee holds the legal title to the property and manages it according to the trust agreement, while beneficiaries retain control and direct the trustee on property management actions. While land trusts offer numerous benefits, they also have potential drawbacks. They provide limited asset protection compared to other entities like LLCs or irrevocable trusts. Setting up and maintaining a land trust can be complex and may require ongoing legal assistance. Additionally, there may be tax implications, so consulting a tax professional is essential. Integrating land trusts with other strategies. To maximize asset protection, consider integrating land trusts with other legal entities like LLCs, which combine privacy with liability protection. Irrevocable trusts and Medicaid asset protection trusts can also enhance asset protection. Common uses of land trust. Land trusts are popular among real estate investors for anonymous purchases, streamlined transactions, and avoiding due-on-sale clauses. They are also valuable for estate planning, asset management for high-net-worth individuals, and charitable giving. To create a land trust, consult with an experienced attorney, select a reliable trustee, draft the trust agreement, transfer the property title, and maintain the trust. Thank you for watching the video. If you found it helpful, please like and subscribe. The same way that an LLC or a corporation is a different entity from its shareholders, a trust is a different legal entity from the trust creator. Trusts are capable of acting independently, owning assets independently, filing lawsuits, and being sued themselves. It is because of these functions that we need to be cautious when it comes to transferring qualified assets, such as an IRA or 401k, to a revocable trust. The transfer of an IRA or 401k to a trust is similar to transferring it to a different owner, such as a different person, a different corporation, a different entity, and in doing so, the IRS considers this a taxable distribution. Similar to qualified assets, when a health savings account and medical savings account are transferred to a trust, they may be subject to taxes. Additionally, transferring a vehicle to a trust may result in the need to pay title transfer fees and additional taxes for issuing the new title. This list is not exhaustive. Other than the above-mentioned items, a revocable living trust may be a good option for the majority of your assets. This means your bank account, your house, your post-tax investment account, etc., should likely be transferred to a trust. You should pay special attention to retitling your assets to a trust to avoid unwanted taxes or other consequences. Contact one of our attorneys to make sure your assets are properly protected.
Welcome to our series on starting a business. Today, we're going to discuss the key legal steps you need to take when starting a new business. Understanding these legal considerations is crucial for ensuring your business operates smoothly and is set up for success. First, let's talk about choosing the right business structure. The most common structures are sole proprietorship, partnership, limited liability company, or LLC, and corporation. Each structure has different implications for liability, taxes, and management. A sole proprietorship is the simplest form but doesn't provide personal liability protection. An LLC offers liability protection and flexible tax options, making it a popular choice for small businesses. Corporations provide the most liability protection but come with more regulatory requirements. Next, you need to register your business. This involves choosing and registering your business name, often called a DBA, or doing business as. You'll need to file the necessary paperwork with your state and local authorities. Obtaining the necessary licenses and permits is another key step. The requirements vary depending on your business type and location. For example, a restaurant may need health permits, while a construction company may need specific contractor licenses. Research the licenses and permits required for your business and apply for them before you start operating. Understanding your tax obligations is essential. Start by obtaining an Employer Identification Number, or EIN, from the IRS. This number is used for tax filings and other business activities. You should also understand your obligations for sales tax, payroll tax, and income tax. Consulting with a tax advisor can help ensure you meet all your tax responsibilities. Creating a business plan is both a strategic tool and a legal consideration. A comprehensive business plan includes an executive summary, market analysis, and financial projections. It helps guide your business decisions and can be crucial for securing financing. Setting up your business finances is important. Open a business bank account to keep your personal and business finances separate. Set up accounting and bookkeeping systems to track your income and expenses accurately. Understanding your business insurance options is also important. Insurance can protect your business from various risks, such as liability claims and property damage. Employment law considerations are crucial if you plan to hire employees. Understand the difference between hiring employees and independent contractors. Comply with employment laws regarding wages, benefits, and workplace safety. Creating employment contracts and an employee handbook can help outline expectations and legal requirements. Protecting your intellectual property is vital. This includes trademarks, copyrights, and patents. Register your intellectual property to prevent others from using your brand or products without permission. Drafting key contracts and agreements is essential for legally binding business relationships. This includes partnership agreements, client contracts, and supplier agreements. Having clear, written agreements helps prevent disputes and outlines each party's responsibilities. Compliance with industry regulations is critical. Each industry has specific regulations that businesses must follow. Ensure you understand and comply with these regulations to avoid legal issues. Seeking professional advice is highly recommended. Consulting with legal, financial, and business advisors can help ensure you're taking the right steps. In conclusion, starting a business involves several key legal steps: choosing the right business structure, registering your business, obtaining necessary licenses, understanding tax obligations, creating a business plan, setting up finances, complying with employment laws, protecting intellectual property, drafting key contracts, and ensuring industry compliance. Taking these steps will help you build a solid legal foundation for your business. Thank you for watching. If you have any questions or need personalized advice, consult with a qualified attorney or business advisor. See you.
A life estate is a form of joint ownership that allows one person to remain in a house until his or her death, then it passes to the other owner. Life estates can be used to avoid probate and to give a house to children without giving up the ability to live in it. They also can play an important role in Medicaid planning. In a life estate, two or more people each have an ownership interest in a property, but for different periods of time. The person holding the life estate, the life tenant, possesses the property during his or her life. The other owner, the remainderman, has a current ownership interest but cannot take possession until the death of the life estate holder.
Whether you're trying to avoid probate, protect your assets, or plan for your family's future, understanding trusts could save you thousands of dollars and months of headaches. But here's the thing most people get wrong about trusts. There are actually 3 simple steps to transfer your house into a trust, and we're going to break down each one so clearly that you'll wonder why you ever thought it was complicated. Plus, we'll reveal the one mistake that could completely invalidate your trust that many people make. First, you need to create the trust document itself. This isn't just filling out some random form online. The trust document establishes who controls the property, who benefits from it, and what happens when you're no longer around. You'll need to decide between a revocable living trust, which you can change anytime, or an irrevocable trust, which offers stronger asset protection but can't be modified easily. Next comes the actual property transfer. This means preparing a new deed that transfers ownership from your name to the trust's name. The deed must be properly notarized and recorded with your local county recorder's office. Without this step, your house never actually enters the trust, no matter what paperwork you've signed. Finally, you'll need to update all related documents and accounts. This includes homeowners' insurance policies, property tax records, and any existing mortgages. Many people forget this crucial step and end up with coverage gaps or compliance issues. The bottom line is this: transferring your house to a trust isn't rocket science, but it does require attention to detail and proper execution to protect what matters most.
In this video, we will discuss the top benefits of having a will. Creating a will is an essential step in ensuring that your wishes are respected and your loved ones are taken care of after you're gone. It is a critical part of estate planning that can save your family from unnecessary stress and conflict. Having a will provides peace of mind, knowing that your wishes will be followed after you're gone. For instance, imagine a family where the primary breadwinner passes away without a will. The family might face legal hurdles and financial uncertainties, adding to their grief. A will can prevent such scenarios by clearly outlining your wishes. A will helps avoid family disputes. Without a will, disagreements about asset distribution can lead to lasting rifts in family relationships. When your intentions are clearly outlined, there's less room for misunderstandings and disagreements among family members, ensuring a smoother transition during a difficult time. By having a will, you maintain control over the distribution of your assets. You decide who gets what and how much, making sure that your belongings, whether they are properties, family heirlooms, or financial assets, go exactly where you want them to go. This prevents the state from making these decisions for you. If you have minor children, a will is crucial for naming a guardian. This ensures that someone you trust will take care of your children, rather than leaving the decision to the courts. The emotional and legal security provided by naming a guardian cannot be overstated. A will can also speed up the probate process. Probate is the legal process of distributing your assets after death. By clearly stating your wishes, you help streamline the legal proceedings, reducing the time and cost associated with probate. This can significantly ease the burden on your loved ones during an already difficult time. Including charitable contributions in your will is another benefit. You can leave a legacy by donating to causes that matter to you, making a positive impact even after you're gone. In summary, having a will provides peace of mind, helps avoid family disputes, allows you to control asset distribution, ensures guardianship for minor children, speeds up the probate process, and enables charitable contributions. In this video, we'll explore how to choose the right executor for your estate, covering key considerations and steps to ensure your wishes are carried out. Choosing the right executor is a crucial part of estate planning. Your executor will manage your affairs, settle debts, and distribute your assets according to your will. Making an informed choice can provide peace of mind for you and your loved ones. An executor has several key responsibilities. They collect and manage assets, pay debts and taxes, and distribute assets to beneficiaries. They must act prudently, be impartial, and maintain detailed records. When choosing an executor, look for trustworthiness and integrity. Your executor should be someone you trust implicitly and who has a reputation for honesty. Financial acumen is also essential, especially if your estate includes complex assets. Organizational skills are crucial, as the executor must handle numerous documents and deadlines. They should also be able to handle stress and make sound decisions under pressure. Availability is another key factor, as the role can be time-consuming. Common choices for executors include family members, friends, and professionals. Family members and friends may have a personal interest in honoring your wishes, but it's important to consider their potential emotional strain and conflicts of interest. Professionals, such as lawyers or trust companies, offer expertise and impartiality but come with costs. Consider the size and complexity of your estate when choosing an executor. A large or complicated estate might benefit from a professional executor. Also, think about family dynamics and whether the person you choose can navigate potential conflicts. Geographical proximity can be beneficial, especially if your estate includes real property. Legal requirements vary by state, but generally, an executor must be of legal age, of sound mind, and free of felony convictions. Some states require executors to post a bond to protect the estate from potential mismanagement. You may also appoint co-executors to share responsibilities, but this can lead to conflicts if they disagree. Alternatives to traditional executors include corporate trustees, who provide professional management, and successor executors, who step in if your first choice is unable to serve. To formalize your choice, include your executor in your will, clearly stating their name and any specific instructions. Communicate your decision with your chosen executor and any successors, and review your will periodically to ensure it reflects any changes in circumstances. Avoid common mistakes, such as choosing an executor out of obligation, overlooking professional help, and ignoring potential conflicts of interest. Make a choice based on suitability for the role. Choosing the right executor requires careful consideration and foresight. To ensure your choice is legally sound and well-informed, consult with an experienced attorney. They can guide you through the process and help you select the best candidate for your needs. Thank you for watching. For more information on estate planning, be sure to subscribe to our channel and visit our website. In this video, we will discuss how to manage inherited property during probate, covering essential steps and common challenges you may face. Welcome to our channel. If you're dealing with the complexities of probate and inherited property, this video is for you. Let's dive into the key aspects of managing inherited property during probate. First, let's understand the probate process. Probate is the legal procedure of administering a deceased person's estate, ensuring debts are paid, and distributing the remaining assets to the rightful heirs. When handling inherited property, you'll need to locate and review the will, inventory the estate, notify creditors, settle debts, maintain the property, and decide on its future. One of the common challenges in handling inherited property is emotional attachment. Family disagreements can arise when heirs have differing opinions on what to do with the property. Sentimental value can also complicate decisions about selling or renting the property. Additionally, financial considerations like the costs of maintaining the property and potential tax implications need to be addressed. Legal complications, such as dealing with multiple heirs or unresolved debts, can also present challenges. If you decide to sell the inherited property, there are several steps to follow. First, prepare the property for sale by making necessary repairs and upgrades, and ensure it is clean and staged. Hiring a real estate agent experienced in estate sales is crucial. They can help you list the property, conduct a market analysis, and market it effectively to attract buyers. Finally, navigate the sale process by evaluating offers, negotiating terms, and finalizing the sale with the help of your agent and attorney. Here are some practical tips for handling inherited property efficiently. Stay organized by keeping meticulous records of all transactions and communications. Use digital tools and software to track important documents and deadlines. Seek professional advice from estate attorneys and financial advisors to navigate legal complexities and plan for tax implications. Communicate effectively with family members through regular meetings and open discussions. Lastly, be patient and compassionate, recognizing the emotional impact of losing a loved one and providing support to each other. In summary, managing inherited property during probate involves understanding the probate process, addressing common challenges, and following practical tips to navigate the complexities. If you need assistance, our knowledgeable attorneys are here to support you every step of the way. Contact us to ensure the probate process is as smooth as possible. Thank you for watching. If you found this video helpful, please like, share, and subscribe to our channel for more informative content. One way to pass a home to your child or children is to make a will and designate a beneficiary for your home in your newly created will. Although estate recovery issues need to be considered using this method, taxes can generally be reduced or eliminated as individuals receiving property upon the death of another are entitled to an adjustment in the cost basis, a step up when there are built-in gains. Gifting the family house to children has consequences that are often unforeseen by families looking to safeguard their assets. Making such a transfer puts you in a difficult position if your children go through divorce, bankruptcy, incur liability due to a lawsuit, or other financial problem occur that may require reselling the house. If you're planning to move out of the house now, you can give the property to your child. However, attorneys generally have better techniques than making such a transfer.